So here's the California definition of assault. As I said, it's unusual. This is not common, but just to share it with you. So an assault under California law is an unlawful attempt coupled with a present ability to commit a violent injury on the person of another. And then we have, whoops, yeah, assault with a deadly weapon. That just involves an actual weapon. So if it's a firearm, it needs to be a real firearm. And by the way, if you're wondering if under California law, this clerk's liquor store, his place of business, would qualify as highly defensible property, that would give him a legal presumption that he was facing an imminent deadly force threat, the answer is, under the law of many states, would be yes. But under the law of California, no. The only property defined as highly defensible property for the purposes of this legal presumption of a reasonable fear of imminent deadly force harm is a dwelling under California law. Different states define the scope of highly defensible property in different ways. A lot of states include your home, your place of work, and an occupied vehicle. California limits it only to the home. And this was the liquor store. It was not his home. So let's take a look. What is the crime of robbery? Now, from an academic perspective, how we teach it in law school is a robbery is a larceny, so an unlawful taking, a conversion of someone else's property to your use, a larceny combined with an assault putting someone else in fear, a larceny being the unlawful taking. So you're not kind of sneaking up behind someone and grabbing their briefcase and running off with it. You're putting them in fear of harm. That's the assault to compel their compliance with the unlawful taking of the property. That's the larceny. So it's an assault and a larceny together, which raises an interesting question. That would be great for a law school exam, final exam again. Was this purported armed robber committing a robbery? Because if a robbery is the combination of a larceny and an assault, but the clerk never experienced assault because he knew he was not facing a threat of actual harm, was there a robbery taking place? Then I would argue there was an attempted robbery taking place, right? The robber failed in his robbery attempt because his gun was ridiculously fake, but he certainly made the attempt. And that's another sometimes ambiguous area of the laws. How do we treat the actual commission of a crime different from the attempted commission of the crime? In theory, you could treat them exactly the same. The punishment could be exactly the same for attempted robbery and robbery. Why should the criminal get the benefit of having failed in his attempt? Would be the argument there. More commonly, the punishment for an attempt tends to be less than for the executed crime. I'm not sure there's any good moral or logical reason for that, but it's not unusual. Let's see. Okay. So, of course, we don't know. This is Orange County. Orange County tends to be a more conservative county of California, although to the extent you can call, I don't know. You know. The people I know who have to deal with Los Angeles as part of their employment often end up living south in Orange County rather than LA County. It's much easier to get a concealed carry permit and all that kind of stuff. So that may make it less likely that this clerk would be prone to be facing a brandishing charge here. Now, there are cases where there's been a brandishing charge. Let's see, what did I do with those slides? Oh, that's the other thing I wanted to touch on. What about if the clerk says, hey, I'm not relying on either deadly force self-defense or non-deadly force self-defense to justify my presentation, otherwise unlawful brandishing, my justified presentation of my pistol. I'm relying on defensive property. Because again, if robbery is the combination of larceny and assault, even if we don't have the assault here because the clerk knew this was a fake gun, arguably we still have the larceny, at least an attempted larceny, a larceny in progress. And therefore, I was not using deadly force, but merely threatening deadly force in defense of property. Well, as it happens, there's a California court case on that I was able to dig up. People v. Chen, and this case is hyperlinked in, or will be hyperlinked in the blog post, the playback version of today. And this involved a guy who was in and around his house, and he had a dispute with his neighbors. And there was a shared fence on their property line, and the neighbors wanted to replace the old fence with a new fence, and they had contractors coming in to do exactly that. But this defendant objected. He lived in the house next door. He thought they were doing it wrong. They hadn't asked the HOA for permission, blah, blah, blah. He had objections, and he called the sheriff's department. And a deputy came out and said to him, listen, this is really just a civil matter. So if you have this kind of dispute with your neighbor, you got to go to civil court to settle it. It's not a criminal matter. So I'll read how the court describes it here. In September 2017, defendant and appellant, he's appealing a conviction here. This is an appellate court decision, case law. Chen called the Riverside County Sheriff's Department for assistance with a neighbor dispute. When the deputy arrived at Chen's home, Chen asked that the deputy stop his neighbors from taking down a shared fence that day. The neighbors, a married couple, sought to replace the fence and had hired contractors, but Chen objected to the plan. The deputy explained to everyone that it was a civil issue and that they should take the matter up in civil court. The fencing company hired by the neighbors arrived at around this time. Before leaving, and perhaps before the deputy leaving, and perhaps sensing the tension between Chen and his neighbors, the deputy told Chen, please do not make any poor decisions and going and attacking people and doing anything criminally so that I have to come back out. What do you think Chen did? You think he made good decisions? Instead of heeding the deputy's advice, Chen went upstairs to his bedroom and began pointing a shotgun from his window toward the neighbors and two of the contractors. So four people. The neighbors, who captured the incident on video, called 911. The deputy, who'd only driven maybe a half a block away, was sent back to the scene and ultimately arrested Chen. Chen was charged with 4 counts of assault with a firearm, 4 victims, right? Now, in most states, that would be a pretty good charge if they were put in reasonable fear of unlawful harm, right? That would be the deadly force assault with a firearm. Each one of those is felonies. And he was also charged with 1 count of brandishing a firearm, a misdemeanor. The jury acquitted Chen on the assault charges. Why? Because this is California, and under California law, an assault is a failed attempted battery. You had to have the intent to actually use the force against the other person, and I guess the prosecution didn't have that here. They couldn't convince the jury beyond a reasonable doubt that Chen actually intended to try to shoot the neighbors as opposed to simply frightening them. So appropriately, under California law, the jury acquitted Chen on the assault charges and convicted him on the misdemeanor. The trial judge granted Chen probation, 36 months, and allowed him to serve via ankle monitor the 3 months of mandatory jail time required by the penal code for brandishing. So that's the mandatory minimum for brandishing a firearm in California. And he was found guilty of that. So he's appealing his brandishing misdemeanor. The ruling of this appellate court: good fences make good neighbors, but here the attempted replacement of a fence led defendant to threaten his neighbors with a shotgun. Following a jury trial, defendant was acquitted on felony charges, but convicted on a misdemeanor brandishing charge and sentenced to 36 months of summary probation. At trial, his position was that he acted in defense of property by brandishing this shotgun. We affirm the conviction on the brandishing charge, holding that displays of deadly force are an unreasonable means of defending property where there is no home invasion or threat of death or serious bodily injury. 19th century California law established this proposition, which remains valid today, meaning the 1800s, folks. By the way, that's also how California is a stand your ground state, not because of a statute. They don't have a stand your ground statute, but because of California case law going all the way back to the 1800s, making it clear there's no legal duty to retreat in California before you can otherwise lawfully use deadly force in self-defense. So, as a matter of law in California, you cannot even display deadly force in the defense of property absent a deadly force threat to persons. What was the deadly force threat to persons here in the liquor store? If the clerk knew, as he says, he knew the gun was fake. It was just looked plastic. He didn't believe it was a real gun. Where's the deadly force threat to persons? And absent that, the clerk would not be justified in pointing his gun at this fake armed robber in defense of property.